Here is a question that sounds simple and is anything but. Once the government hands you money, signs the grant, wires it to a bank account with your name on it, can it just reach back in and take it back? This month, a full federal appeals court gave an answer, and the answer was no, or at least, very likely no. The entire bench of the D.C. Circuit, sitting together, ruled 6-4 that the Environmental Protection Agency likely broke the law when it tried to claw back $20 billion in grants it had already awarded. Not $20 billion it was thinking about spending, $20 billion already promised, already obligated, already sitting in the bank. Tonight, the case of the money the government tried to ungive, and the quietly brilliant legal move that stopped it. Let me lay out the money first because the numbers are the case. Back in 2022, Congress created something nicknamed the Green Bank, formerly the Greenhouse Gas Reduction Fund, $27 billion to push loans into clean energy projects. In August of 2024, the EPA awarded $20 billion of that to 8 nonprofit lenders, and the money was placed in accounts at Citibank. These grantees are not abstractions, crew. They are community lenders and clean energy projects that were told, in writing, this money is yours, go build. Then the administration changed, and the new EPA moved to terminate the grants and pull the $20 billion back out. So the grantees sued. Their chief executive, Beth Bafford of Climate United, said the agency was trying to, quote, unlawfully freeze and dismantle the National Clean Investment Fund. The whole fight comes down to a single question a court had to answer. Whose money is that now? And this is where the ruling becomes genuinely clever, so stay with me, because it is the whole ball game. When you sue the federal government over money, where you are allowed to sue depends entirely on what kind of claim it is. If your fight is a contract dispute, the government broke a deal, you go to a special venue called the Court of Federal Claims, and the most you can win is money damages, later, after the fact. By which point the program is dead and the projects are gone. But the majority here did not treat this as a broken contract. It treated the grantee's claim as something else. Unlawful interference with funds they already own, sitting in their accounts at Citibank. And that reframing changes everything. Because if the money is already yours and the government is wrongly blocking it, your case stays in ordinary federal district court, where a judge has the power to do the one thing that actually matters: order the agency to stop, right now. An earlier 3-judge panel had called this a contract case and thrown the block out. The full court just overruled them. Same facts, different door, opposite result. Now, 2 things about this ruling tell you how close and how careful it really was. First, the vote. 6-4. That is not a rout. That is a bench that genuinely split, with 4 judges willing to let the clawback proceed. Their argument was not frivolous either. They pointed out that Congress, in a law signed in July of last year, actually repealed the Green Bank provision and asked how a court can keep protecting a program the legislature just erased. 6 judges said the money was already obligated before that. 4 said that no longer matters. Second, and this is the tell, the majority won and then immediately hit pause on its own decision. It stayed its own judgment to give the EPA time to run to the Supreme Court. Read that combination like a prosecutor reads a hedge, crew. A court confident enough to reinstate the block, but cautious enough to hold the door open for the highest court to take a look. That is a court that knows exactly how big this is, and that it may not have the last word. So here is the verdict, and what to watch. Strip away the clean energy label and the grant paperwork, and what is left is one of the biggest executive power questions there is. Can an administration reach back and reclaim money that Congress already obligated and a bank already holds, simply because the policy fell out of favor? For now, a divided but full appeals court has said, likely not, you cannot ungive what has already been given. But hold both halves of this in your head, the way you hold a case that is not yet closed. The $20 billion is protected tonight, and the community lenders counting on it still cannot spend a dime of it, because it is frozen in legal limbo until the Supreme Court decides whether to step in. A win that keeps the money safe and keeps it locked in the same breath. So watch that door, crew. Watch whether the Supreme Court takes this case, because that is where the question of who really controls the nation's purse gets its final answer. I'm Madeline, and this is Pixel Politics.